The first session we have this afternoon is on whether the tribunal is bound by the policies of the Workplace Safety and Insurance Board. And the format for each of the sessions we're going to have this afternoon is going to be the same, that someone from the employer side is going to present for 10 minutes, someone from the worker side will present for 10 minutes, and following the second presentation, then the presenters will take questions from the audience. We'll continue to take questions as long as time permit. So I'm going to just introduce the first two speakers for the first session. And the first speaker is Dave Brady. I've known Dave for many years. He's a senior partner at Hicks Morley. He's past chair of the CBAO Workers' Compensation Section and a past chair of the Workplace Safety and Insurance Law Specialty Committee. Dave has probably appeared in more leading case appeals for employers than any other lawyer in Ontario. And he's probably spoken at more programs on workers' compensation law than any other lawyer in Ontario as well. Dave commands tremendous respect for his ability in tribunal appeals, and it would not be an exaggeration to describe Dave as the dean of the employer side workers' compensation bar. On the worker side, we have Dave Wilken. And Dave Wilken actually replaces Ian Anderson on the program. Ian had to withdraw and strongly recommended that I ask Dave to see if he would be able to replace Ian. Dave's a lawyer with the Industrial Accident Victims Group of Ontario, better known to most of you as IAVGO. It's a community legal clinic that provides representation to injured workers. Prior to that, he's worked with other injured worker organizations such as Advocates for Injured Workers Consultants, and the Office of the Worker Advisor. I've seen Dave in action at the tribunal. He's an outstanding advocate for injured workers. He's written many articles and has been involved in many community education programs for injured workers and injured worker groups. And he also has a particular interest in this topic. So with that, I'm going to turn it over to Dave Brady and Dave Wilken.
Thank you, Dan. You've always been very kind, and you've been kind, I guess, to both of us, David and I. I'm delighted to be here and delighted to share this topic with David. I know he knows an awful lot about it, and probably more than I do by a long shot. There is a paper that you have. I'll tell you I'm not going to be referring to it. What it does contain is a discussion about Section 126 and what is policy and all of the various things that have arisen in the case law that the tribunal has written thus far. I think the case cites are very recent, and those cites will assist you in terms of the cases that you have dealing with policy. Obviously, board policy is something other than what the board says this is how we do it. So that's a focus of much of the tribunal writing thus far. What I want to do this afternoon is really talk to you more about an experiential side of 126. And what that means is I've had a couple of experiences where the board has used its policy-making power strategically to right what it thinks is wrong about tribunal decisions. And I come to this topic as a result of being involved in a couple of cases with a little bit of passion. You know, Section 126 makes sense because you have to have a connection between the board as the manager and the administrator of the safety and insurance system in Ontario, and on the other hand, the tribunal, which has a final and binding last step in the appeal process position and really creates the law. So there is a tension in the Act that 126 is seeking to address, the tension being administrator manager, how to make this thing work operationally, and someone who doesn't have the responsibility for operations, that's the tribunal, that makes law that will affect, of course, the operation of the board. So the tension is something that 126 seeks to address. Makes sense. I think 126 does a reasonable job. Obviously, it doesn't answer the questions that the legal drafts person did not anticipate, but it seeks to put in place a relationship between the board and the tribunal. And, you know, the cases are the stuff of cool legal analysis, and that's what the paper is seeking to address. I guess my passion comes from what I said at the outset. I found that the board has, on occasion, used Section 126 as an end run of WSIAT decisions it doesn't like. It relies on its statutory power to determine, that's the word in 126 in the last subsection, policy issues that the tribunal and board disagree on, where the board confidently says to the tribunal and to all of us advocates, we hold the trump card and we can change the facts of an appeal by changing the policy so that we can win a case that would otherwise not be winnable, so that we can retrieve a case that we've lost, and now we're going to recreate circumstances and put the loss behind us. There are two examples I'm going to give you of how the strategy of board policymaking has been used to kill tribunal decisions. One before Bill 99, pre-January 1, 1998, and one after. The similarities are quite striking, I think. In 1996, I was involved in a case at the tribunal on behalf of a large retailer. The board had decided that installing carpet sold at retail was really residential construction and reclassified the activity from the retail rate to the construction rate 4 times easily the amount of the assessment per $100 of payroll. On the facts, carpet installation was run at a loss. It was only offered in order to sell the carpet. If you didn't sell the installation, you didn't sell the carpet. That was the marketplace. None of us would buy it if we had to take it home and put it down ourselves. The facts found by the tribunal were carpet installation was an integral part of the retail business and could not be separated for premium rate setting purposes. What a happy result. Saved the client hundreds of thousands of dollars into the future. However, that wasn't the case. The board changed its classification policy concurrent with the change in the regulation that dealt with this kind of assessment matter, and advised the client that effective January 1, 1993, which is when the new classification system went in, that its success was limited only to 2 years, 1991 and 1992, and from January 1 of 1993 on, we're in a different world. What they said was that as a result of the new classification policy, what you're really doing in selling carpet and carpet installation is you're involved with home improvements and renovations. And strangely enough, just by coincidence, it happened to be the same rate per $100 of payroll as residential construction. Back to square one. So, Eureka, new rules, revisited results, a win where there was a loss, and a vitiating of the client's success at the tribunal, and basically saying to the tribunal that its decision was, in effect, rendered meaningless. The client's response was this. We sought to have the hearing reconvened by the same panel that heard the case in its original circumstances. The tribunal granted that request. We went back to that panel. We asked the panel clarify the result that we had received in light of the new policy and the new regulation. The WCB at the time was asked to participate in the oral hearing and decided not to, and instead sent some written submissions. Well, in January of 1997, decision 323/93R, which I'm going to quote from, and it's got a nice quote to it, issued a second decision on the real merits and justice of the case. It decided that its original decision was entirely as it was stated to be, ordered the board to implement it forthwith, and confirmed its finding that carpet installation was an integral part of retail activity and could not be a standalone activity for this new policy. Now here's the quote at page 6 of the decision. The submissions of the Workers' Compensation Board would limit the scope of the decision to the date upon which the new regulation took place on January 1, 1993. The Board's submission was also founded on the assumption that the employer's activity in installing carpets was a separate and severable operation from its primary activity of retail sales. This is a misunderstanding of Decision 323/93. I thought it was, that's a kind way of saying it. The panel did not determine that the employer carries on activity in the area of carpet installation in addition to retail operations. The panel determined that carpet installation was a necessary and integral part of its ability to compete and perform activity as a retail vendor. Given this panel's clear factual finding that carpet installation cannot be severed from the primary activity of the employer as a seller of retail goods, the second aspect of the WCB's position is not persuasive. The second aspect has to do with policy, which is the topic today. This is what the panel had to say. The panel has reached a factual conclusion regarding the nature of the employer's activity. It is a factual conclusion which binds the board. There is no doubt that the board has discretion to enact appropriate policy which provides interpretation of statute. However, once a finding of fact has been made by the appeals tribunal, unless those facts are demonstrated to have changed, the factual conclusions must survive even in light of a new policy. Now, I'll bring this circumstance to the present. This is the current example of I think, an end run that has not yet, the story has not yet come to a close. That concerns casinos. On September 21, 1998, decision number 1203/98 was rendered by the tribunal. And it ruled that food and beverage workers of a casino are not covered by the Act because they work in an activity which exists solely for the support of gambling. Restaurants in casinos are operated at a loss to keep customers feeling good and close to the tables. Now, you all know that. You may not, however, have been the players that are big enough to get what are called comps. Comps are food and beverage, free parking, limos, hotel rooms, the things that are not directly paid for, but are given to gamblers depending upon how much they gamble and over what period of time. That's not been my circumstance. The tribunal found that the food and beverage operations, similar to carpet installation, could not be carved out of the gambling activity of the casino. And because the casinos are not covered by the Act, they determined that this carve-out was inappropriate, and therefore all of the people employed by the casino were not covered by the Act. I know the board did not like this. The casino, however, was very happy, saving hundreds of thousands of dollars into the future. Well, not so. February 2000, the board issued a new policy. Now, the new policy is identified as a clarification policy. It goes back to the classification system, which was introduced January 1, 1993. Sort of rings this resonance of carpet installation, same policy. The new classification scheme was, as I mentioned, the same touchstone, and the board determined that in this February 2000 clarification that food and beverage people are again covered and that the client has to recomply with the Act. It took 2 years to disentangle. From the 1996 decision to 1998, it took 2 years to disentangle. So now we're back in the re-engagement process. As you can imagine, we've sought to have the tribunal reconvene again with the original panel. We do not know whether that request will be granted, but that's what we're seeking to do. And of course, we will argue that the findings of fact about the casino business are the findings that whatever the policy is cannot move in one direction or another. So when it comes to 126, there are 3 things I think for advocates to consider. 2 of them are found directly in 126. One of them is, as a matter of law, the board by policy has no jurisdiction to expand its scope beyond what it has been given by the legislature. It cannot change its statutory role. Two, in terms of the applicability of statute, policy, as far as applicability is concerned, it cannot make policy which is arbitrary, discriminatory, or in bad faith. These are fundamental admin law propositions. And we hope the tribunal, and we believe the tribunal, will state those propositions clearly. And if there is an application to divisional court, I would hope that the board would have to make it and not anyone else. And the last thing to say to you is, coming out of these two cases, deal very carefully with the facts. And with respect to those facts, determine which of those facts, if found in your favor, would render board policy inapplicable. So you've got legal propositions to deal with and factual propositions to deal with, and there's more to deal with than you might first appreciate by reading 126 through its 8 subsections. Thank you.
Okay, I will also not be dealing directly with the written materials that I submitted, but I'll just quickly review what these are. Some mention's been made of my experience in this area, which is actually a bit truncated due to the way that things happened in the particular case, which is included in the materials. It's decision number 809-98I, then I2, and then the final decision, which are all behind tab 2 as an appendix. And that was the first case referred back to the Workplace Safety and Insurance Board by the Appeals Tribunal with a finding that the policy forwarded to the tribunal by the Act was not authorized by the Act. But in fact, that process was derailed by the finding or the admission by the board that they did not even really have a policy on that issue, which the tribunal could properly apply. So the first thing behind tab 2 is an excerpt from the submissions that our clinic made on behalf of the injured worker in that case, arguing, first of all, that there was no policy. Then secondly, that the board should not engage in this review under section 126 for a number of reasons, revolving around bias, questions of bias and institutional bias, and an improper statutory scheme of imposing board policy onto the tribunal. That last point is really what I'm going to be addressing today. I suppose that it would be accurate to say that our submission was, if the board interprets this section of the Act to say that the tribunal must absolutely follow board policy in every case, the board is wrong. And to the extent that they would try to enforce that on the tribunal should not listen to them. And if the tribunal listened to them, that at that point we'll see you all in divisional court and we'll win. And I guess.
Yes, sir. Yes, sir.
The board, as I said, did not address any of those points in their direction to the tribunal, made a point of saying that they were not making any admissions with respect to any of the administrative law issues raised in our submissions. So in a way, we were preempted from making our real arguments to the tribunal on the question that I want to address right now, which is who has the final say on what is the law and policy of the Workplace Safety and Insurance Act. And my argument is that it remains the same party that it always was, which is the tribunal, that we pretty much actually know that based on the pre-1998 Act and the use of Section 93 by the board and the implementation of the Section 93 reviews by the board in tribunal decisions. This is not what most people, at first glance certainly, and I didn't at first glance, take this to be what Section 126 said. Because we know that the intention of those who cooked it up was to turn the tribunal into a trier of fact alone that would not even interpret the Act. When I went back to research where could I find the earliest draft of what is now Section 126, I found it in a paper presented by the Business Caucus of what was called the Premier's Labor Management Advisory Committee under the NDP government, in a paper on entitlement, where these Business Caucus members were suggesting that the act must be amended to strike out the significant contributing factor test and put in a dominant cause test, strike out the presumptions in favor of work-relatedness, the benefit of the doubt to the worker, compensation for chronic stress, chronic pain, and even chronic organic back injuries that do not have an acute traumatic cause. And then they had this to say about the tribunal. In many of its recent decisions on appeals, WCAT has gone beyond the adjudication of facts and have attempted to interpret the act. We believe this is... I know, don't mock the afflicted. We believe this is beyond their role and mandate. In doing so, it has established policy which has had the effect of broadening entitlement without regard to the financial consequences. The jurisdiction of WCAT needs to be limited to the adjudication of facts only, and appeals for which there is a lack of policy or for which policy interpretation is required should be referred back to the board, and adjudication of the appeal suspended pending the board ruling on policy on the matter in question. So this bears a superficial resemblance to Section 126 in requiring the tribunal to suspend its proceedings and refer a matter of policy back to the board. If you go back to the pre-1998 Act, however, and look at Section 93, you'll find that a lot of the wording in Section 126 was really there in Section 93. That really what we have is a change of the relationship of the institutions. Under Section 93, it was the board that had to initiate a review of a completed tribunal decision, but, and this is the sense in which it's importantly very much the same as Section 126, the board did have then the power to determine an issue of interpretation of the policy and general law of the act, and then to direct the tribunal to reconsider its case in light of that determination. It's actually very similar to the wording of Section 126, and I want to suggest that what we have now is an institutional framework where in some ways, in fact, the ball is now in the tribunal's court. The board can no longer choose its battles as it likes, and that this puts the tribunal in a position of perpetually reviewing board policy, quite contrary to the intention of those who at the political level initially thought this up. The drafting of the section simply doesn't carry through their intention. So that when an issue of policy is raised, we've already seen in the two decisions in the appendix that the tribunal will take upon itself to decide whether or not this is a policy. And if it's not, in the most recent decision, the finding was that then there's no reason to go to the board of directors at all. We will simply apply the act. Then, to make its determinations on whether the policy applies to this case and whether or not it is authorized by the act. If it finds that the policy is not authorized, it makes the referral back to the board with its reasons. And then this is the part where Section 93 and the experience under that section becomes helpful for us, since we don't know the answer yet for sure under Section 126. What happens if the tribunal sends something back to the board and says, your policy is not authorized by the act? Say that the board of directors had come back and said, that is our policy. Chronic stress is not compensable. You must have an acute traumatic incident. And that policy is authorized by the act, and that is our direction to you, the tribunal. Based on the way in which the tribunal received the directions under Section 93, I'm going to suggest that what a panel would appropriately do at that point is to first examine the process that the board used to arrive at that direction. And this is really the only or certainly the most prominent example of a situation where the tribunal inserts itself into the board's process rather than simply reviewing a decision. And this was done in several of these implementation decisions. So they will make sure that the parties had a right to make submissions to the board, that the body making the decision, if it's not the full board of directors, was actually properly delegated to make that decision, and that the board issues proper written reasons which address all of the substantive issues raised by the parties to the appeal. Then, if the board makes it through that, the panel would further make it another decision, review the decision itself to see whether or not the finding on the issue of law is patently unreasonable. Finally, even if the panel was convinced that all of this had been done properly by the board, it would then apply the decision, which, based on the particular facts of the case, could mean, it would apply the policy rather, could mean not following the policy to the letter. So I'm going to give you now the numbers of a couple of decisions. And I'm going to tell you that everything I just said was already decided by panels of the tribunal in Section 93 implementation cases. Decision number 4289, decision 12R2, and decision 64887R. And I'd like to read to you an excerpt from that last decision, which is reported at 32 WCAT Reporter 1, and I'm reading from page 11. As we noted above, if the tribunal has received a valid direction from the Board of Directors and sees no reason to doubt the legal validity of the Board of Directors' interpretation of law and policy, the tribunal is required to apply that policy to the particular case, which is pretty much what 126 sub 1 says. And then adds, as I hope future panels will, if it is appropriate to do so. However, it will not be appropriate to do so if applying that interpretation will result in what the tribunal considers to be a result which is contrary to the real merits and justice of the case. In the present case, the panel accepts the legal validity of the Board of Directors' interpretation of law and policy. It appears to us that the board's policy is consistent with the Act and not unfair or unreasonable. However, having said that, the panel is concerned that altering the original decision in this case may nonetheless result in a decision which is contrary to the real merits and justice of the case. And in the result, they refused to reconsider their decision, which had to do with with awarding benefits in a chronic pain disability case prior to the Board of Directors' retroactivity date. My submission is that nothing in the new Act changes that position or directs the tribunal to do anything other than that. The tribunal continues to have the final word in every particular case, and ultimately it has to decide each case within its jurisdiction to decide the case based on its real merits and justice. It has to apply board policy, but in some cases, applying policy means not following it to its letter. What is changed by Section 126, obviously, is this huge institutional mechanism for the board to now come up with what are the policies that apply to every single case, forcing the tribunal to look at this issue in every single case. And I think that at the end of the day, that is going to, if it has any effect at all on what anybody does, it will have to affect the board, who are now going to have it in their face over and over and over again when one of their policies is not authorized by the Act. And they have some which are clearly patently unreasonable and so unfair that no court in this country, I don't think, is going to side with the board when push comes to shove and this eventually winds up in court. So, thanks very much.
Questions? Why don't you guys take it?
Sure.
Yep.
I have a question about section 93 and section 126. I understand
Yeah.
Give me a chance to look at it at that point, or if that's not necessary. But the loop happens before the decision's made now.
Well, the decision of the tribunal is final. I mean, I suppose the board could ask, there's nothing probably preventing the board from asking for reconsideration, or any other party, and obviously any party can attempt to judicially review the decision if they think that the panel hasn't appropriately applied or followed section 126. I don't think so.
Well, arguably, yes. I'm kind of instructed a little bit by what David has said, and he's given me 3 arguments I didn't know I had. You know, it strikes me as what does the word apply mean? And maybe apply has a whole spectrum of application that goes from, you know, very little to a lot. I think the merits and justice, where you're not bound by legal precedent, is what both the board and the tribunal are supposed to do. Policy, I think, has, as far as an attempt by the writers of the language, is to find a balance between the board such that it can operate and the tribunal. I think when it comes to real merits and justice of the case, that's where I would argue, as David suggests, everything that is available to you to have the tribunal make its independent mind up, and that's what I would expect of the tribunal. So it's a long way of saying it much is determined by the case that you have, but ultimately I think the tribunal, by its independence, is going to be persuaded by anything that you might argue in your case to maintain the independence of its decision-making and really give real effect to merits and justice. So I hope that's where the bottom line is.
Time for one more? No? Okay. Well, thanks very much, Dave and Dave. It was a great
Dave.
presentation.
Thanks, Dave.
Our next 2 speakers are Julia McNally and Dave Gorelle. The next session, as you'll see from your program, is to deal with chronic pain. There's some new rules that have come out in relation to chronic pain, and Julia and Dave are going to tell you about them and give you the worker and employer community perspective on the proposed chronic pain rules. Dave, I introduced once this morning already, so I'll do the Campbell soup version of his bio. Dave's a partner at Matthews, Dinsdale & Clark, a management-side law firm. He's chair of the Workplace Safety and Insurance Law Specialty Committee. He's a highly experienced employer representative on workplace safety and insurance law issues. Julia McNally, in addition to her 2 undergraduate degrees and her law degree, has an LLM from Cambridge. She articled at Parkdale Community Legal Services. She was staff lawyer for 5 years at Aboriginal Legal Services and later at Neighborhood Legal Services, where she specialized in workers' rights. She's currently an associate at Green and Chirkover, and she practices in all areas of labor law with a focus on workplace safety and insurance law. Julia is one of the most active members of the executive of the CBAO Workers' Compensation section. So again, I'm grateful to have 2 speakers of this quality willing to come forward and tell us about chronic pain.
Thanks, Dan. Dave and I have discussed and we agreed I'm going to start first, and then Dave is going to act as devil's advocate.
That's right.
I'm hoping that there aren't actually new rules yet on compensation for chronic pain, or else Dave and I have missed the boat on this issue. We're here on the understanding that the rules aren't yet developed, and that the board is in the process of looking into developing new rules for compensation for chronic pain. In preparing for today, I actually pulled out my old WCAT reporter and reread Decision 915. And my first thought was, here we go again. Haven't we already done this, and do we really need to redo it? And I guess the theme of my comments today are that, in my view, we don't need to redo this. Decision 915 offers us an excellent template for determining chronic pain cases. We don't need to rethink the whole issue. It was thought out exhaustively in 915. And in fact, when you look at the list of counsel and decision makers on it, it's a bit of a who's who of the workers' comp community. So I don't think we need to relitigate the whole issue and rethink it. But oddly enough, nobody asked me before they started on this process. And here we are, 3/4 of the way through rethinking chronic pain. What I want to talk about quickly is sort of the board's process up to date, a quick summary of the reports, the specialist expert reports that have been issued on chronic pain, and then some brief commentary on the going forward. In terms of the process, as you all know, in the Workplace Safety and Insurance Act, Section 14 suggests that the board wants to relook at compensation for chronic pain. It's fairly clear from the Jackson report, which gave rise to these amendments, that what the government wanted to do originally was to put a cap on compensation for chronic pain in the hope that they would save lots and lots of money. Before that process was finalized, voices out of the medical community in particular said to the government, actually, we disagree with your assumptions that are motivating this rewriting of chronic pain. Why don't you pause and study the issue in more depth? That was done. What's come out of that process are 2 reports, an expert advisory panel report and a policy panel report. The expert's role was to look exhaustively at the issue of chronic pain to determine what the current understanding of chronic pain is from a diagnostic perspective, from a treatment perspective, from a prevention perspective. The role of the policy panel was to take that information and to come up with proposals for compensating chronic pain. That now has been done. Both reports were issued by the board in February of this year, and they are available. There's a helpful address on the WISIB's website. So if you don't already have those reports, they're actually reasonably, especially the medical one, interesting reading. Where the board is going is their deadline for consultation is June 16th. So if you're interested in the issue, you should get your comments into the board before then, and then I assume they will embark on a process of rewriting the compensation for chronic pain rules. What the two reports have done, the expert report, as I said, is a reasonably comprehensive look at where chronic pain knowledge is today. I'm not going to review the report for you. I recommend it to you for reading. But I think there are 2 interesting things coming out of that report. One is it challenges a sort of pre-existing assumption that the mind and body were different processes. And it challenges the traditional mind-body dualism that has underlain the analysis of chronic pain up until recently. And certainly reading Decision 915, there is a fairly sharp distinction drawn between psychogenic chronic pain and chronic pain that is thought to have an organic origin. What this report does, I think it tries to do, is say we have to transcend that. You can't draw a sharp distinction between what is psychological and what is physical. That with increased scientific understanding, we realize that psychological processes are, by and large, physical processes, and that the 2 are intertwined. So this report, I think, attempts to transcend that dualism. It also highlights a number of the new theories of physical causation for chronic pain. A number of them that are highlighted are the realization that there are probably disc and joint problems that you can't see on traditional x-rays. So there's a move to develop newer and better machines to detect these problems. There's research going on into neurons and receptors and how they fire to determine whether or not you can track pain. So there's a lot of very interesting, radical new research into understanding pain. The expert report has attempted to present this to show in part that, in fact, one of the problems with chronic pain is we don't understand it well enough, and that there's a lot more to learn, and it's not time to close the door on chronic pain when we still don't know what the future holds. So I think the expert panel, although I don't agree we really needed to go through this whole process, the expert panel actually provides advocates with a useful tool to better understand chronic pain when you're advocating on behalf of clients. The policy panel report takes the expert panel report to come up with suggestions for the board. It has done so in two basic areas. They've looked at prevention and management, and they've looked at compensation. I'm not going to go over the prevention and management. The theme of the report is early intervention. That makes perfect sense. The theme of the report around prevention and management is that you should be, in terms of dealing with chronic pain, looking at multifaceted treatment programs and not restricting what's available to the injured worker. The bigger issue is how to compensate it. The panel came up with two options. The first option is basically continue as usual. Board, keep compensating it the way you've been compensating it to date. The second option would limit compensation at 12 months. The second option seems to come out of quite directly out of the Jackson report, which was suggesting a cap on compensation on the theory that we'd compensate the injured worker not because the chronic pain was actually caused by the workplace injury, but give them a hand in adjusting to their new chronic situation. So the theory's a little bit suspicious in my view. It's compensation because we're nice, not because it's caused by the workplace accident. So I think I'll probably let my bias show. And I'll move to the last part of this talk. In my view, the board has to adopt the first option. It is the only option that is consistent with the Act, that is consistent with jurisprudence not only in the Tribunal but in courts across North America. And it is the only option that is consistent with the Charter. Again, I go back to 915. It's a well thought out, exhaustive decision. It analyzes the court's decisions. It analyzes the many factors. It looks at how does thin skull play out in chronic pain cases. It looks at the question of causation. It looks at how you balance significant contribution test. It goes through all of the issues and comes out the other end saying, yes, we must compensate chronic pain, and yes, we can do it. And it provides a template for doing it, and it provides a template that we've used more or less for the last 13 years. There is no reason, and I've certainly seen no reason set out in the policy panel, why we should leave behind this system that has been thoughtfully developed and that it works. Flipping the coin for a second, when you look at option 2, in my view, it doesn't make any sense. Why would you compensate for 12 months and then not compensate thereafter? If you have decided that this pain is connected to the workplace, then you should compensate until there is a break in causation or until the pain stops. If you think this pain wasn't caused by the workplace injury, then you shouldn't compensate it. There's no jurisdiction in the Act to compensate for problems unrelated to work. So in my view, there's no rational basis to provide 12 months and then no more. The reasoning in the certainly that's set out in the Jackson report, I would also challenge. There is highlighted in that report a concern that you can't, there are so many factors at play, you can't determine which one caused the chronic pain. Well, again, and I feel like I'm plugging this decision, but 915 considers that. It says there are many factors going on. The role of the tribunal is to determine, was the workplace injury a significant contributing factor to the injury? If so, it's compensable. There are often in cases before the board and the tribunal many factors. That's never prevented the tribunal from being able to sort through them. And certainly they are able to sort through them in chronic pain cases. So I would say that one of the motivating concerns of the Jackson report is actually unfounded. Finally, and I haven't thought this issue all the way through, but I have this nagging feeling that a decision not to compensate chronic pain would bring the act afoul of the Charter. It strikes me that it's creating a distinction between, a discriminatory distinction between some groups of disabled people and other groups of disabled people. And following on the reasoning in the Supreme Court decision in Battleford, I would argue that's not an appropriate distinction, that all injured workers who are suffering a disability as a result of a workplace accident must be compensated on an equal footing, and that you can't pick and choose amongst them. And in particular, that the goal of saving money is not a justification for discrimination amongst injured workers. So if this government wants to save money, they're going to have to find another way other than preventing a whole bunch of workers from receiving compensation. So I'll leave it at that.
Well, as Julia has indicated, I feel as though I've been charged with taking the other side of the coin in this one and playing the devil's advocate and trying to make some presentation to justify Section 14. So I'll do my best. How many people in the audience believe in such a thing called chronic pain? Look at that. The hands are almost universal. How about that? This is going to be a tough crowd. Okay. All right. Well, the place I'll try to start then is at the beginning. And I guess I have a few concerns that the scientific and advisory panels have kind of missed the boat. As Julia mentioned, there are no real rules out yet, but we do seem to have a pretty good template as to where this area is going. The reason I say they may have missed the boat is because I have some concerns that they've taken it for granted that chronic pain disability exists as a separate compensable heading. The medical experts on the scientific panel really didn't seem to include any doubting Thomases. And I don't know whether anybody's taken the time to review this document. This is the little one. The medical one's way bigger, so it takes a much longer period of time to go through. But right at the outset of the paper, it indicates that the composition of this medical scientific panel are basically experts who come into it armed with the belief that chronic pain exists. And just from a scientific analysis standpoint, I guess I would have liked to have seen the other side of the coin canvassed and at least had that assumption challenged by members of the medical community that do doubt in the existence of it. I deal with medical experts fairly regularly in presentation of cases, and they tend to be very reputable witch doctors and so on, so we can depend on what they say. But I hear a lot of them challenging the assumption that chronic pain exists at all. Many of them don't seem to have the time of day for it. What I hear time and time again is that the system itself may be responsible for the creation of this condition because it rewards it. Well, that's interesting. Okay. I've got you so far. That's interesting. Or that the person has not been properly diagnosed or treated with respect to the organic injury itself. Now, that second one is fairly easy, I think, to comprehend, because what we're talking about here is an improper diagnosis, that the pain persists 6 months or more beyond the usual healing time, because perhaps the physicians have improperly treated the condition or they've been unable to locate the source of the problem. So what that boils down to, I think, is that we as human beings aren't as smart as we make ourselves out to be. We think we've got fantastic diagnostic tools and state-of-the-art things like MRIs, CAT scans, bone scans, and so on. But to me, they're helpful diagnostic tools only. They don't necessarily get to the root of the problem in most cases. You're dealing with a very incredibly complex mechanism in the human body. If you affect one part of it, there's no way to tell what's going to happen to other parts of it. You're dealing with a lot of interdependent connections. So my concern is that if you muck up one little connection so that maybe a neurotransmitter isn't released when it should be, Or in the case of chronic pain disability, perhaps it is released when it shouldn't be, and that's what the perception of pain is coming from. There's still always potentially an organic root at the basis of these chronic pain issues. We just may not be able to detect it or sort out the complex interactions that are producing it. The other thing in this, this issue of maybe there's an organic injury at the root of it is that doctors aren't perfect either. And I'm sure we've all had situations to deal with where we've seen someone go off to one doctor, and it's only after you've consulted several or more physicians that maybe someone is able to identify what the real source of the problem is. And again, maybe it, and quite likely it will boil down to an organic condition. It puts me in mind, certainly in my own family, a family member suffers bouts of flu-like symptoms every 4 to 5, 6 months. Right out of the blue, these problems will hit. I've been to several physicians to try to sort out the cause of it. Been diagnosed as gallbladder problems, as just some sort of a stress condition. They really don't know what the problem is, and yet it does manifest in very, very severe conditions. Nobody would doubt that there's something very severe going on. You just can't figure out what it is. But that's no reason to go to a default setting that just because we can't figure out what it is, it must somehow be a chronic condition, implying that there's something operating that's not organic. There's a very good chance, I believe, that there is an organic root to the problem, and that the doctors have simply not been able to figure out what that problem is. We also tend to see it a lot in cancer cases. So to me, what this argues against is compensating a label called chronic pain disability, and argues in favor of the detailed multiple expert analyses at the beginning of the claim, and that's one of the recommendations that we see in the panel's report. The other concern that I've heard from the physicians is that the system itself is responsible for creating this condition. And how does this one go? Well, it seems that some physicians, anyway, are under the impression that the system, meaning the compensation system, workplace safety and insurance system, is rewarding the complaint of pain with ongoing benefits. I did an undergraduate degree in psychology and economics long ago, and my hazy recollection of the psychology aspect was that there was this idea of positive reinforcement. If you put the mouse in the maze and put the cheese at the end of the maze and the mouse keeps going through, it eventually learns the behavior that it'll get cheese if it does this maze properly. But again, I think most of us can conceptualize it in other terms, and maybe family terms, and that is with children. I have a couple of kids. They fall down. They seem to be very embarrassed by the fact that they've fallen down. Absolute pandemonium ensues. You'd think they were murdered, and at the end of the day, there's no broken bones, there's no cuts, bruises, scrapes, or anything else. And so what do I usually do is just brush them off, try to console them, give them a pat on the back, and away they go. I don't want to minimize what injured workers are feeling, but it does go to this issue of whether or not the system is rewarding the pain behavior by providing ongoing benefits. And I think that this is one of the other reasons why there may be a limit contemplated to the benefits under Section 14 of the legislation. It may be a good idea to place a limit on the benefits in the legislation, and then again, let the workers argue on the merits and justice of the case, those situations where perhaps the benefits should be extended beyond the statutory limit. At least I would suggest that if there's a limit, perhaps that will take away any motivation aspect on the part of the worker to just be claiming the pain behavior or manifesting the pain behavior in order to receive benefits. Anyway, getting back to this first issue, does chronic pain disability exist at all? I'd summarize by saying that I don't see that this is a question that's ever even been addressed by the expert scientific panel. It's basically presumed. There's a reasonable hypothesis as well that chronic pain disability is a learned response or perhaps a rewarded behavior. And there's a concern that it's a default setting for the medical community, that if they can't come up with a diagnosis and they have the 5 minutes available for most workers and non-injured workers. Last couple of times I've been to see a doctor, it's just, you know, there's no review at all. It's in, out, and maybe a prescription and maybe not. But given that minimal amount of time, it certainly weighs against any sort of a finding that there's a chronic pain issue. To me, it's just a default setting for the physicians. What's the problem with this particular head of benefits? Well, the system gives the benefit of the doubt to the fact that the condition exists at all, and so do the doctors, absent this analysis. And from a benefit entitlement standpoint, the system basically has to give the benefit of the doubt on a balance of probabilities to the injured worker who's claiming entitlement, because there's no way that the injured worker can prove that there's a source for the pain. I can claim I'm in pain right now, and there's no way you could dispute it. You have 2 layers of benefit of the doubt, and that to me is creating a problem for the workplace safety and insurance system. It would create a problem for any insurance system. You have to be able to insure a risk, and an insurance company can calculate a premium to insure an identifiable risk and the type of injury that's likely to be sustained, and that's how we get into our rate groups and the analysis of premiums. You can't do so with a claim that's relying on 2 levels of benefit of the doubt. Again, you could claim chronic pain disability tomorrow, you could claim to be in pain, and there's no way of proving otherwise. If you're going to recognize and allow a benefit for it, you almost have to impose a limit on the system, or we get into the issue of what the minister seemed very, very concerned about today, which was the ultimate survival of the system. You have to be able to fund the system, and it can potentially be financially threatened if there's a benefit being paid that's not reflected in the premiums that are being collected. The WSIB also has to manage the CPD claim more effectively, and that's another issue in the policy panel's report. The discussion in the advisory panel's report regarding the WSIB's role in education and prevention talks about a number of different issues. And they talk about the idea of improving the management of claims, and the panel recommends that the board adopt a decision tree approach, and that the first branch of the decision tree include a thing called red flags. Now, I'd like to just take a moment and review a few of these red flags with you, and basically the absence of scientific support for any of these red flags. Dave, do you want to wrap it up? Pardon? I have 2 minutes to wrap it up. Okay, well, maybe I won't be able to review any of these red flags with you. Suffice it to say that there isn't a red flag, that the idea is early intervention on the part of the board. And what the board wants to see happen is early on, the board gets in, addresses these red flags, whether they're family situations or whatever. And what the red flags are based on is the evidence of this scientific panel's report. And what they did was list a lot of these red flags, and then beside them list what the strength of the support was for the particular red flag. And the thing that caught my attention is that there is only limited or moderate evidence in support of these particular red flags. And if you turn until a point that's way later in the document from where the red flags are listed, you'll see that moderate evidence is defined as one relevant high-quality scientific study or multiple adequate scientific studies, whatever exactly that means. Limited evidence, which is what the majority of these red flags is based on, talks about at least one relevant adequate scientific study. That to me is a pretty light basis on which to come up with diagnostic items for the board to be applying to determine whether there's going to be a chronic pain disability case coming up. It's very, very light. And they recognize this. At page 28 of the policy panel report, it says many of the factors that were examined were found to play some role in the development of chronic pain. However, none of the findings are supported by strong evidence. Over the page to 29, with respect to the question raised in the Jackson report, to what extent do work injuries contribute to the development of chronic pain, the scientific panel's report, taken as a whole, provides some evidence that work in general may play a role in the development of chronic pain, but it's unclear whether work factors contribute more or less than the other factors that were studied. I sit back and think, okay, here's yet a third level of the benefit of the doubt that we're applying to these cases. We'll give the benefit of the doubt that chronic pain disability exists at all. We'll give the benefit of the doubt that the worker has it. And now we'll give the benefit of the doubt to the fact that it's work-related. Because none of the studies, if you look at them, really support the fact that it is. So at the end of the day, we've got 3 levels of benefit of the doubt being applied to these chronic pain cases. That, to me, is what makes this different from every other type of compensated head that's out there. In Julia's paper, she comes to the conclusion, or makes the statements that it submitted, that the only appropriate and just way to compensate chronic pain, and the only approach that is consistent with the Act and the Charter, is to treat chronic pain disability like every other injury. My position, as I'm forced to take in this case, is that it's not like any other injury and therefore shouldn't be treated like every other injury, and that's why you need a statutory limit on it. And I see what they've produced in this report as being 2 types of statutory limits. I wish I had time to go through it all for you, but one is basically on the benefit amount that's going to be paid out, and the other one is on the duration of benefits and type of benefits that are going to be paid out. The only other thing that I noted was that in Julia's paper, she talks about on option 2, the injured worker with chronic pain would appear to receive a maximum of 24 months benefits. That's just towards the end of her paper. I'm not sure that that's correct. When I read this thing, it looks like it's 1 year worth of benefits, and even under the approach that she's promoting, and this is a very well-written paper, by the way, I'd commend it to you. Even under the approach that she's promoting here, it looks to me to be limited to a 1-year period. Anyway, thank you very much, and sorry that I had to praise you that.
We got time for a couple of quick questions. Questions rather than statements, I hope. I'm not following you, sorry. Who does the benefit of the doubt go to? Yes. Well, basically, I sat back and tried to look at this issue from a clean slate perspective, and it looked to me like the benefit of the doubt had to be given basically to the idea that chronic pain disability exists at all. And one of the things that I was going to get into is the idea that maybe the system wants to try to compensate it under another heading. Julia, for instance, is looking at compensating it pursuant to traditional mechanisms, which is through a non-economic loss award. And maybe that's the way to go. Compensate it, continue to compensate it through a NEL award, but what I see this proposal as doing, without saying so, is assigning like an additional amount for pain. So if you have a back injury, you might get a 20% NEL award, and there might be a range of up to 5% available for if there's a pain component to it. You might get an additional 5% or something within that range. Benefit of the doubt on the next level is, again, to the worker, because anybody can come forward and say, I've got pain, and there's really no way to dispute it. And then at the final level, I was talking about giving the benefit of the doubt that it's work-related, because, again, this is an issue that is raised in this paper. That's what their biggest concern is that there's not a lot of evidence that says chronic pain disability has necessarily a work-related source. Maybe it's attributable to non-work-related factors, and as a compensation system, we can't be compensating people for non-work-related factors. So again, I see the benefit of the doubt in all of these issues basically accruing to the benefit of the worker.
The 2 policy choices set out really come down to, at the 12-month point, you either say adjudicate each case on its merits or nobody gets compensation for chronic pain. Mm-hmm. Given that you've just said there's a lot of medical uncertainty about chronic pain, how can you say no one gets compensation? There's no medical study saying chronic pain is never related to the workplace. So how can you say we shouldn't at least adjudicate each case on its merits?
Well, I think I actually did say that at one point just to cover myself because I'm not really, I mean, what can I say? You get to the end of a year, it looks like you're right. Either you're going to get a pension, it looks like you're going to adjudicate it according to the old model, in which case it looks like a pension's available, in which case it looks like they're going to try to limit benefits for pain and not really treat it under its same old heading of chronic pain, just build it into a Nell award that recognizes the issue as an organic issue. Or you're going to get the, during the tail end of your 1-year period, the worker would get a period of labor market reentry services and other type of counseling assistance to try to help them cope with it. Those seem to be the two models. Either one I see as a limit on the benefits that are going to come forward for chronic pain.
I just don't see what rationale there can be to eliminate benefits after a year when there's no medical basis for that.
Well,
I can understand individual employers and individual claims questioning whether a chronic pain disability exists. And that can be adjudicated for that case. How can you say no one even has the option of having their claim adjudicated when there's no medical basis for that?
well, again, I stress that I'm not the one saying it, but on the other hand, I see all kinds of limits in the Act as it is. For instance, under the old voc rehab retraining exercises, what would it be? It would be time limited in terms of the job placement assistance afterwards. People didn't often come up with jobs at the end of it. You had to draw the line somewhere. So I think they would typically start out at six months worth
That was
of.
never in the Act or regulations, right? That was board policy, which is far different and it could be extended. They're talking about making regulations in this case.
Well, as Dave said, we have to draw the line somewhere, and I think we'll have to draw it here. Thanks very much, Dave and Julia. A wonderful presentation. We're going to break and come back in 15 minutes.